You're right.
I'm good, thank you. How are you?
I'm fine as well. Okay. Do you want to open up the document and share your screen?
Yeah, just 1 second. What document are you on about? Sorry.
It's the same protocol, conveyancing protocol.
Okay, just 1 second.
So, did you get a chance to read about the laws and the regulations regarding conveyancing?
Yeah.
Uh, Particularly the part where you have to do ID and AML, any fraud liabilities, and all of those kind of liabilities. Did you go through them?
I looked through the case laws that you
Hmm.
suggested for me to do, and then obviously the guideline sets out some guidances, A to Q,
Mm-hmm.
and I've had a look at those as well.
So, can you give me an overlook of what you've read and what you've understood?
So I know that obviously the protocol relates to obviously conveyancing transactions, and it applies to all solicitors, so those acting for the buyer, the seller, and also the lender. And obviously, the kind of aim of the protocol is to make sure that the process runs smoothly and that everyone to the party of the transaction is obviously aware of what's going on, and that they're all treated fairly throughout the procedure. And also, obviously, the solicitor's main duty is obviously to act in the client's best interests, and obviously, they are bound by professional obligations to their client throughout the transaction. And obviously, the protocol sets out some obligations of a solicitor that they have to give to a client. And obviously, these regulations support best practices to help to reduce delays or disputes during the transaction process. And then obviously, the guidance sets out some guidances from A to Q. So, for example, ensuring the transaction runs smoothly and all relevant information is shared. Also, making sure that obviously you manage your timing and that you respond promptly to obviously any queries that your client has, as well
Mhm.
as obviously ensuring that you comply with the most up-to-date regulations. So, like you said, with the contract form and the standard conditions, making sure you're using the most up-to-date ones. And then obviously um, just recording any advice that you've given to the seller or to the buyer or to the lender, and obviously maintaining a high standards throughout the entire process, really.
Yeah. So, I mean, that's basically the executive summary of it. And that is what you need to understand is that at the end of the day, you're representing your client to the best of
Mm-hmm.
your abilities. And if you do not do so, and if you're caught in negligence or in a negligent behavior towards the timeline, or if you're caught in a negligence behavior towards the transaction, um, it can cost you your license as a solicitor.
Yeah.
Can cost you a high rise in indemnity insurance of your professional indemnity. You can see a number of issues and consequences if you're not really careful uh,
Mm-hmm.
with the transaction of conveyancing. Because as we've spoken about this before, conveyancing is a high risk industry because it's got a transaction and flow of money and flow of an influx and an outflux of cash, um,
Mm-hmm.
and financial obligations are there as well. So you've got your clients to answer to, you've got your lenders to answer to, and you've got the law society to answer to as well. So any of the obligations that you miss out, or if you're in breach of all three, any of the three obligations, like the lender's obligations, the client's obligations, or the law society's obligations, you would be in breach and you could land in a lot of trouble, which obviously is the entire uh, um, uh, intention of avoiding for every law firm. That is another reason why you should go for a regulated law firm, a well-known law firm. Not, I mean, high street practices are really good, but you need to look out for good high street practices, because that just builds up on your CV. Oh, this girl's worked there. Oh,
Mm-hmm.
Erica, she's worked there. She's worked in that law firm, and they have a certain reputation associated to them. So if you're not within a good law firm whose best practices aren't really up to mark, you can land into trouble with the other employer or with the law society, because if they're going into administration and
Mm-hmm.
you've worked for a law firm who's gone into administration from the SRA or the law society or the CLC, um, it's really not worth it. So you should be very careful. But regardless, to say, um, these checks and balances, as you said, they're there for a reason, and the reason is to avoid consequences to
Mm-hmm.
the client, to the solicitor, and to the lender, because all of them hold a substantial interest and a stake within this transaction. Right. So, can you share your screen and open up the protocol, please?
Just one second.
So, last we spoke, can you just give me a rewind of what we spoke about and where we were at the transaction stage?
Um, so last time we were talking about obviously the contract stage, and so after you obviously opened your client's file, and that you've obviously checked their identity and their bank statements and everything, we move on to the checking of the title. So checking the property title, as well as obviously gathering some information from the seller. So you conduct your pre-contract inquiries. So you have the fittings and content form, the property information form, and this is obviously filled in by the seller regarding all the details of the property.
We were talking about the seller because we are at the seller stage.
Yeah,
We've
yeah.
not gone to the buyer stage. So show me the perspective of the seller. So if imagine if you were the seller solicitor, how would you act, and what steps would you take? What did we talk about?
So you'd have to check their identity, and then obviously you have to check their, like, they own the property. So looking at the title register,
Definitely, yes.
um, and then obviously checking if there's any restrictions in their ability to sell the property.
Good.
Um,
Yes.
and yeah.
Yeah. That's really it. So the most important part is checking the register, the title document.
Mm-hmm.
So imagine if a person, again, let me reiterate on my point. Imagine if a person is selling on a trust and there's a restriction on that on that property or on that title that they would have to execute the trust in a certain way,
Mm-hmm.
or there is a restriction that two people own the property and they cannot sell as sole proprietors. So, I mean, if so, to cover the interest of the other person, they cannot sell it as sole proprietors until an intervention of the court. Yeah, where
Mm-hmm.
there's a grant of probate or anything else that's been made, or there's a debt certificate. If there's joint tenancy, or if there's tenancy in common, then you'd have a grant of probate or a trust that's been made, or anything else. So you need to look out for these things within the register, because it's your ultimate responsibility to take out that restriction. Now imagine if there's a lease, or if there's a restriction that that there's a freehold and a leasehold title, and the buyer solicitors, they ask you to merge these two titles. Now merging of these two titles mean that the freeholder is the leaseholder, but there's a lease as well, and there's a freehold as well. So they say that, oh, can you merge that? You can do, but you can also ask them in these instances that this is a post completion requirement. Can you do that yourself? We can provide you all the documents and we will answer any requisitions that come across your way in terms of that lease or that register. Sorry, in terms of that lease and that freehold. Yeah. There can be instances where the buyer solicitors they ask you in their inquiries that can you deal with a specific restriction. That restriction they will mention, but it's just best practice if you deal with any and all restrictions on your part, regardless of if the buyer solicitors say that or not, because it's implied that you would have to deal with all the restrictions. Yeah. So, and then we've got, okay, so now that we sent, now we, in the last session, we spoke about protocol documents and the contract pack. Now that you've confirmed instructions on your letterhead and you've sent as supplemental documents all the contract pack attached to your email, you've sent that. Once that's done, you should be expecting a letter of inquiries and a letter of confirming instructions. So that letter of confirming instructions would be on letterhead, and it would say that we so and so confirm instructions that we act on behalf of the buyer, name this, for the property this. Yeah. And they would confirm that instructions, and sometimes they do that within the same letter that they raise inquiries in it. So inquiries would be the way I do it is quite simple. It's um, property information form inquiries. That is one heading. You've put all of your inquiries in one, and then you've got fittings and contents forms inquiries all in one, and then you've got title inquiries all in one, under one uh, um, um, uh, paragraph or under one headline or heading, and then you've got any supplemental inquiries that you want to raise about any documents that they've attached, and then that those inquiries basically are sent to yourself. Now, the inquiries that you need to deal with are to do with the registered title inquiries. So you cannot answer questions or inquiries that are relating to the inspect that are basically up to the inspection of the property or regarding the inspection of the property, because you, number one, you do not live in that property. Number two, you've not seen that property on site because that's not your job. Your job as a lawyer or as a solicitor is to look at title inquiries or the legal inquiries or the legal aspect of that property. So all other inquiries, such as which relates to the TA6, like the property information form, or the TA10, the fittings and contents form, that is to be dealt by the seller. So what I normally do is, or what any lawyer does is, they put all of the inquiries that are with regards to the seller, put that in a document and highlight it for them or number it for them to say, can you please respond to these inquiries using the same numbering, or just put your response right in front of the inquiry itself. Yeah. So they respond to those inquiries to the best of their knowledge. They may want to discuss these inquiries with you because they do not understand what's been asked of them, such as, oh, can you please share a planning permissions or a building safety regulation certificate? And that's been asked by the buyer solicitors, and he doesn't know because he's not from this country. So, what is a planning permission? What is a building safety regulation certificate? So you as a solicitor need to know these definitions. You as a fee earner need to know these definitions because he's going to ask you about these. So your next task or your next assignment is what to do with these things, such as the EICR, yeah, such as EPC, such as building regulations and compliance certificates, and planning permissions, land charges, Section 106 agreements, and any other planning permissions and planning agreements. So you need to define these, and we'd do a kind of an exercise where I'm the client and you're the solicitor,
Mm-hmm.
and I'd ask you a question, and I'd just ask you about these things. That what are they? And you just in simple English, you'd explain them, not in legal terminologies or legal jargons, because I can't understand them. I'm a client. I don't have the knowledge of law that you do. Yeah, you need to explain them to me. Where do I find these documents, for instance? Where can I grab these documents from? Yep.
Mm-hmm.
So any kind of agreements, like the Section 106 agreement or any development agreements, you'd usually find on the local authority's website. Any planning permissions you can find on, I think, there is a website of planning permissions as well, but I'd have a look. You can research that as well as part of your assignment. And then you've got the EPT, or you've got the fencer certificate. So the fencer, it has its own website. So regarding the fencer, if it shows, or regarding some planning permissions, if it shows on the local authority search of the buyer solicitors, then you do not need to provide them as per the protocol, because it would say in their local search that it's registered. So you can say that we do not agree to providing these. If you want them, you can have, or you can avail them at the expense of your own client. You can say that, because it in the local search, if it shows up as registered, that means that there is no issues. This work's been done legally, and it's been done with the permission of the local council, and the local council has approved it, and it's been registered. So you do not need to show anything else.
Mm-hmm.
And anything that shows within the local authority that it shows as registered, you do not need to provide. If they still insist upon it, saying that there is an issue with this, or there's that, some documents you would need to provide, such as the Section 106 agreement or any planning agreements. So even if it says registered Section 106 agreement, this, you would still need to provide that. Or any correspondence with the leaseholders, you'd need to provide that. You need to get in touch with because that's a third party, and that's
Mm-hmm.
your third party. So that's your client's third party, yeah? So any developer, any freeholder, anything else, you need to do that. And you would need to realistically deal with any restrictions that has to do with registering another document, such as a deed of covenants. Sometimes it's the buyer solicitor's responsibility to deal with those inquiries. You'd have to look at those inquiries and see that, is it your responsibility really, or is it, the buyer solicitor's responsibility? So you can, with restrictions on the register, you can play around with them. You can see that, oh, is it, you'd have to look at the wordings. What does it require? Is it an action from yourself? So, for example, no disposition. Disposition means that no disposing of this property of the registered estate without the consent of the freeholder, named this as this, uh, saying that the buyer or the seller has complied with the restrictions. So this kind of a restriction would be dealt by uh, the buyer. Once you've provided them with the management company information or the management company pack, the management pack or the LP1 pack, they can get in touch with the freeholder and or the management company or the landlord or the managing agent. They can get in touch and they can have this done. But if there's a restriction on the property regarding a discharge of a charge or a redemption related restriction, you'd have to do that because that's on your part of the transaction. So there are some restrictions that are on our part of the transaction, and there are some restrictions that have to do with the buyer solicitor's part of the transaction. So anything that needs to be registered
Mhm.
post completion, and it's not a restriction that needs to be taken out of the register, that is to do with the buyer solicitors. And anything that has to do with completion, that the restriction needs to be removed on completion, that's got to do with the seller solicitors. Does that make sense?
Yeah.
Yeah, perfect. So once you've dealt with those restrictions, you need to obviously, so whenever you're sending the inquiries to the client, you send them the documents as well that they've signed, such as the property information form that they filled out, the fittings and contents form that they filled out, the title register as well. Because the title register, one of the inquiries is usually that can you please confirm that your clients have upheld or have not been in breach of the covenants, restrictions, rights reserved, and rights granted, whether the title register or in the conveyances or transfers mentioned within the title register. So you need to confirm that with the client that have they been in breach. The title plan as well, usually that's up for inspection, self-inspection by the buyer, but it doesn't hurt for you to basically confirm that with your client, saying that can you please confirm that the title plan shown and the red marking of the land within the title plan, it just depicts the actual and true boundaries of the property. You can also add that, I mean, our client has confirmed this, but it is up for your client's inspection to see that does it really include what is included with the title register?
Mhm.
Well, sorry, the title plan. So, and then so before that, you need to do a bit of compliance work as well with a third party, such as a lender. So if there's a lending that needs to be redeemed, and that some monies that need to go to the lender, so you would need to ask for a mortgage statement from from your client. They would provide you with an initial mortgage statement, and then you can on that basis you can get a initial redemption statement from either lender's exchange or an LMS or through other means as well by either writing to them or just by calling them. So, or they just fax it to you. So it's different to every lender. Usually it's by email, but I've got some lenders as well that do fax in this time and age as well. So you have to bear with them. You have to see, you have to have a look what really is their method of sending documents. So once you've done that, you've basically done most of the due diligence on a sale transaction.
Mhm.
Now it's just to and fro from there onwards. You send the replies from your client. Once the clients respond back to you, you send those replies to the solicitors with any associated documents. The solicitors, they basically review it. The buyer solicitors, they review it. If they're satisfactory, they move to completion stage. Now, the exchange and completion stage is a different stage. That's the third and final stage. Before that, they might ask for, if they're really nosy and if they're really, like they want to get involved and they want to show you that, oh, they're really knowledgeable, they might ask you just some stupid questions. Or they might just put in some stupid inquiries. As per the protocol, you can only, and you're only bound by the protocol where it's a legal inquiry. For example, they can say, "Oh, can you confirm?" Because I used to do that, and I mean, this is a very huge mistake that, I mean, junior conveyancers make, but once you get to that seniority, you understand that, oh, you don't really need that. So what I used to do is I used to ask the buyers, sorry, I used to ask the seller solicitors that, oh, can you confirm that there are no parasites within the fitted units, such as the cupboards or anything else, and are they in good condition? They just say that this is in breach of the protocol. It's up for your client to inspect, blah blah blah, and we'll not respond to you. So they just say that, and I can't do anything because, again, that is in breach of protocol. So you do not need to be in breach of protocol. You need to ask questions, and you can only answer questions to basically deal with substantial information about the property, but without it which the proprietor will be in breach, such as having not having any planning permissions. The council can come to them and say, "Oh, you're in breach. We'll do this, 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 or we do that, that, that." Yeah.
Mm-hmm.
So any document that gets you in breach, the buyer solicitors will ask you for it. If you do not have these documents, what do you do?
Um, if you don't have the documents that they need, sorry,
Yeah,
would you have to try and obtain them, or
you can, but if you can't, if they're not available,
would you just say to them that it's kind of beyond your scope of obtaining them?
doesn't matter. Still your responsibility, isn't it? So if something's missing,
Mm-hmm.
how do you protect the interest of the other party?
Would you not just say that it's up to them to find that information, or
No,
no?
that's your responsibility because you're
Oh,
the seller
okay.
solicitors. So because you're guaranteeing about the property,
Mm-hmm.
having all documents, having everything that's really required. So if you don't have a document, what do you do?
Not quite sure.
No worries. I mean, I'm not putting you under the gun here or under the target. It's just that I'm asking you a question. It's fine. So you indemnify them.
Oh, okay.
Indemnity insurance. Yeah. So indemnity, what indemnity does is it's just a go-to response of every conveyancer. But what does an indemnity actually do? You do your research a bit on this as well. On a baseline, an indemnity would only cover the financial breach and the financial obligation. It will not cover the the breach itself. So
Mm-hmm.
imagine if you've, I mean, gone berserk and your client's gone berserk and they've basically built the property and extended the property and it goes beyond the scope of the title plan. The title plan is this. It shows the property as this. Yeah. And you've created the property as this. And you've
Mm-hmm.
extended to this extent. Property was this. You've extended to this. So this part here, which is an extension, they would say, how did you attain that? Number one, you can say that this property was a barren land, or you've not. Let's just say, keep it a bit simple. You've not attained that, but you're using this bit of this belt,
Mm-hmm.
and it's being used by all of the other surrounding residents as a parking. Now, either they'd ask you to provide a statutory declaration that you've had no issues during your proprietorship and the council's not come for you in terms of breach, or and with that they just ask for indemnity as well, because they can just come back and say, oh, you've been in breach, but it doesn't matter because you've not fenced that part of the land as your property. So you can always move your car, you can always do that, you can always do everything, but you're still in breach. So if there's a financial obligation and if there's a financial breach, that indemnity would cover that.
Right. Okay.
But that indemnity will never cover the breach itself. So
Mm-hmm.
if the council still wants to come to you with regards to a planning permission breach, and it says that we're going to bulldoze this off, it won't cover that. So the indemnity really is just to cover the financial charge, the financial obligation, or the financial breach. It doesn't cover the breach itself. So if there's a document missing, such as a land document or a title document, usually you can argue at times, you can say that the age of this document
Mm-hmm.
suggests that the obligations within it have either freezed or do not exist anymore, such as if there was an obligation of giving access to horse carts
Mm-hmm.
in today's day and age, and if this obligation and this piece of land or this title is now in, let's say, Leeds city centre, where you'd not find any horse carts.
Yeah.
So that obligation has freezed. So some obligations have a freezing time as well, because
Mm-hmm.
they might they might be appropriate for that time, but they're not appropriate at this time and age. But the buyer solicitors can still come and say this accessway has an effect, a continuing effect on anything that basically it just gives access to people who are riding something. They can say nowadays that cart's been replaced by cars.
Mm-hmm.
So this is an access way for cars, and this is an access way for this, or this is not. So you'd have to look that does that conveyance contain anything substantial that it needs to be provided. Sometimes a further dated conveyance, a later dated conveyance, can replicate the covenants within the previous conveyance. So you can just say that those covenants are basically replicated within the later date conveyance, but they still ask for indemnities, and you need to provide them. Or you can say that since we're not in any breach, and since there is, uh, nothing missing, so we refuse to provide them. And the buyers then what they do is they just go back to their client and say, "Do you want to cover yourself? I mean, you get the indemnity because the indemnity is the responsibility, and it's a one-off payment, but it's still the responsibility of the sellers." to indemnify the buyer. So imagine if there's an indemnity costing, or the premium of it is £150. So you're indemnifying the further buyer during their ownership for £150, and that's it. So it's not really a big deal. Yeah.
Mhm.
So, and then you basically, once all of the inquiries are done, you'd be asked to send a PA13 form, which is the completions undertaking form. So can you please share your screen, and can you just Google a PA13 form, please?
Yep. So sorry. What was it? Sorry, TA.
PA13, yeah. Tango Alpha 13. Your screen's blur.
Is it blurry?
Yeah.
Sorry, it's missing. Let me try again. Can you see that?
Yeah, it's still blurry, but it's fine. No worries. Just can you open that document? They just provide you with one document, I think. So yeah, I think the go.
Sorry.
Go up. I think, is there a link for the, no, sorry, that's tier 6.
Yeah, I think it's further down here.
Oh, this,
Yeah.
yeah, there we go. So yeah. Mm. Now it's clear.
Are you able to see that?
Yep. That's fine. So next page. Yeah. So this page. Put in the property information, like the property address, postcode, details of your client, the seller, and if you've got two sellers, there's 1, 2, first name, last name, and then you go to the next page.
Just there's only 2 pages, I'm afraid.
No, there should be more.
Let me see if I can download it.
Oh, why are there 2 pages, really?
Just one second. I think it's text. Maybe this one.
Yeah, go down. Let's see if this is the full document. Go down. Down. Yeah, perfect. That's fine. Yeah, that's fine. That's great.
Yeah.
Even if that's still not the up-to-date version, but I mean, it's got the same things. Yeah. So go up. So yeah, property address, seller information, and the buyer's information. Go down. So now vacant possession. So the contract would say that the property. So you remember we spoke about that. The property is sold with vacant possession.
Yeah.
So who will the keys be left with? You ask the seller. that will the keys be left with yourself or your agents, or I mean, I've never had this where will be left with seller solicitors, but nobody knows. So it's either one or it's either other, where it says it will be left with the seller and the seller will hand over the key itself.
Mm-hmm.
And then you've got vacant possession of whole or part is not being given. Please confirm that authority to the tenant to pay the rent to the buyer will be handed over to be included within the documents. So this has got to do with the property where there's a tenant in situ. So a tenant in situ is basically after completion, the property is basically a buy to let kind of property.
Yeah.
So where there's a tenant in the property after completion and the vacant possession is not promised, that's basically where you need to take that as well. I've got a matter where I'm dealing with such a property where it's leasehold flat and there's a tenant within it, and my client basically is saying that he's fine with the tenant because there's no lender. Usually, if
Mm-hmm.
there's a lender, they would want vacant possession. Until
Right.
and unless it's a buy to let one. A buy to let one, they still want vacant possession, but it would be you who'd be leaving that property that you basically are on a mortgage on.
Mm-hmm.
Yep. So, I mean, so you're either confirming this or you're not. It just depends if vacant possession is being given. Go down. So if the title is unregistered, do you hold all the title deeds? Again, it's got to do with the title, unregistered title, and obviously the seller solicitors would have the original conveyance, the original transfer, the basically where the root of title, where they're deducing the root of title, that document or any of the original documents of the title, they'd have it, and then you'd say either yes, and then no. If no, then please give details. You just say that this is a registered property and all documents are on the HMLR. And then you've got please list all these documents to be sent on completion. Again, if it's unregistered or if there's a document that is only available, the original is only available with the seller, you just list them down here. Go down. So will completion take place at your office? Yes, because completion usually takes at the office of the conveyancer, the solicitor, acting for the seller. And then we wish to complete through the post in accordance with this by post. Please confirm that you undertake to adopt the code. Yes, you do. The mortgage and charges, if there are any, that you undertake to redeem or discharge in your replies 5.1 and 2 are those specified for the purpose of paragraph 7 of the code. Take and take. Yeah? Because
Mm-hmm.
if there's a mortgage on the property, you need to redeem it as the seller solicitors redeem any mortgages, any and all mortgages within the title. Please state the exact amount payable on completion. So if there's no chattels payment, like there's no fittings payment that needs to be made, you just put in the purchase price. That's it, as per the contract. If not, if it is not just a balance purchase, please provide copy receipts on any rent, service charge, or other payments being apportioned. So you need to, if there's an apportionment that's been made, do you know what an apportionment is?
No.
Okay, apportionment is usually when there are, uh, I mean, if the yearly payment of a service charge,
Mm-hmm.
ground rent, uh, is to be made
Mm-hmm.
on the detriment of the seller. So the buyer solicitors, they would hold some monies off
Mm-hmm.
to pay off any obligations that may come from that either leasehold property or from that management company that's managing the lease.
Mm-hmm.
So those are apportionment figures. There's a full calculation of apportionment figures how you do it. Yep.
Yep.
Every every law firm has their own, but usually the law firms that nowadays they high tech software, and that apportionment figure is just there, so you can basically do that. So, I mean, it's got to do with this, and then we please provide details of your bank. So these are the bank details of the solicitors.
Mm-hmm.
Yeah. So you provide name of bank, address of bank, sort code, client account name, client account number, and then you go down. If there is no mention of reference number, then in your email to the solicitors, when you're sending them this document, you say, can you please put, whenever you're making payments, please put in the reference, the unique reference number of our law firm, blah,
Mm-hmm.
blah, blah, whatever your law firm's reference is, the unique reference for this matter, you put that in so that once your accounts department confirms that they've received numerous payments, like a list of payments, you can see that, oh, this is my client's or my matter's payment. So the mortgages and charges that you need to redeem are, so if you go onto the title, any title register, you find that the charge registered or restriction, it would say that we undertake to redeem. So you just copy and paste all of the restriction and the registered charge proprietary date. Yeah,
Mm-hmm.
go down. And do you undertake to redeem the discharge? And yes, you do. And no, I mean, confirm no, you do not. You do not need to take 5.3 because you do undertake the Law Society's code for completion by post. So, and then you go down, and then you put in your details. I mean, the seller solicitor's details, such as if you're not a solicitor, but you're still an authorized person, you can put in your details and say for and behalf of your law firm, or just put in your law firm's name. And the buyer solicitor, you put in their name, you date this document, and you send it as a PDF or as an editable PDF to the other side solicitors. And that is when basically completion and exchange happens.
Mm-hmm.
So in an exchange and completion, do you want to open that specimen contract if you remember that we had?
Do you know the name of it? Sorry. So.
I think it was a contract for sale, Law Society. Law Society, yeah. I think they'd have it. Yeah, there we go. So standard conditions of sale. Yeah, there it is, I think. Standard conditions of sale. Let's see if that's one. Yeah, there we go. Right. Okay. So now, once we're exchanging, so
Mm-hmm.
exchange is when we've no. So how does exchange work? On the day of exchange, you if you're acting for the seller, you'd type in an email saying, "Dear sirs," or "Dear name of the client, please note that we're about to exchange on your transaction." They would be aware of the exchange date beforehand, because once you've agreed an exchange date, that is when you tell your client that this date has been agreed. Is this agreeable to you? They'd say
Mm-hmm.
yes. I can move out, or I don't really care because I'm already out of the property. So I mean, everything's fine. You can agree to this date. So once that date is agreed, on that date, in the very beginning, and in the morning, you just come into the office, type in an email to the client saying, please note that we're exchanging on this and completing on this date. If it's a simultaneous exchange and completion, we're exchanging and completing on this date. Or if it's a separate one, so you just put in a heading exchange and heading completion. In underneath the heading of exchange, you say, please note that we're exchanging on your behalf with regards to this property. Uh, please note that after we've exchanged, we uh, hold 10% of the buyer's deposit. So the 10% is basically the 10% of the purchase price. We'd hold that. held to our strict order uh, to basically confirm this transactions going forward. Once exchange has been done, you are bound to abide by the conditions of the agreement, the sale agreement, and you're basically telling them the liability of exchanging. So
Mm-hmm.
once we've exchanged, that is that the contract's been signed, and there is no going back. So he can't say, "Oh, I mean, I don't want to sell it."
Right.
Yeah, because there would be damages and there would be litigation then in terms of breach of contract. So what happens in an exchange? So you call up the buyer solicitors, or the buyer solicitors call you up. One of you recites the contract's contents. So reciters are like, you'd say date. So this is the date of agreement. Yeah.
Mm-hmm.
And you'd basically, I think, have we gone through this before?
Yeah.
Uh, yeah. So you just recite through everything, and you say, and at the end, you'd have basically at this stage you'd have signed documents. So you'd say, and once you've exchanged, so you'd say the uh, buyer solicitors, you're this, seller solicitors, you'd name yourself. You'd say, I'm the seller solicitor, and you'd say, law society formula P. You'd need, I mean, another thing in your assessment is what does ABC formula mean and what is their significance? And then you note the time down as well. So the time is very important. That what time have you exchanged? So if you've exchanged at 12:52, so your time and my time should be the same.
Mm-hmm.
Yep. So if we exchange at the same time, so it should be 12:52, and you put that at 12:52. Yep.
Yeah.
You've done that, and you basically have exchanged. If it's a simultaneous completion as well, you should be expecting funds on the same day into your client account. Once you receive those funds, that is when legal completion has happened. And now,
Mm-hmm.
what you need to do as the seller solicitor or the seller conveyancer, you need to release keys to the buyer. You call up the estate agent, or if there's no estate agent, you call up the seller and you say, completion has taken place. Can you please hand over the keys to the buyer? Can you please release the keys, or can you please hand over the keys? And they just confirm by email, or you can just confirm by email because the estate agent or the seller will tell you that yes, the keys have been released, or yes, the keys can be collected from us now. And you basically uh, confirm by email to the solicitors, the buyer solicitors, that the keys have been released. Please ask your client to collect them, and that is it. So now what you need to do is you need to redeem the mortgage. The redemption is the next step, the post completion step. So you take the bank details, you pay off the mortgage, and once that's done, the mortgage the lender would basically confirm at their end after some days that the charge on the property, the financial charge on the property, has been removed. With all of that done, once you send the monies to the lender, send the monies to, if there's any indemnity, send the monies to the indemnity policy people, send the monies to the estate agents as well. Once that's all done, you've spread out all the monies, you've sent everything to every single person that you need to send to. The last thing that you need to do is send the monies to the client. Now, that is where you need to do the completion statement. You do the completion statement that this is the uh, sale price, this is how much the property was sold for, um, and minus our fee, estate agent's fee, indemnity, uh, I mean, anything else, any third party fee that you've paid, sorry, the lender's fee, redemptions that you've made, and the remainder of the amount you send to the client with the completion statement. Once they've agreed the completion statement that, yeah, that's fine, perfect, that's good, you send the monies across to them. Before you do that, you confirm bank details with them. So you'd ask them to send you a bank statement at the very beginning of the transaction and at the very end of the transaction that this is the same bank statement that they've had, and they're the same client, and they've got the same bank details. The bank statement would confirm bank details. You just call them up and you'd confirm it with them. You say, "Oh, you're this person." That's
Mm-hmm.
fine. You send the monies across to them. You ask them that if is there a reference that you need to use. So they say, "Oh, can you just put in the address of the property or this and that," and you send the monies across, and that is the transaction finished. You do not need to do anything else. I mean, that's one transaction finished, and you need to close this file now. And then closing of files is a very different topic, and it's got to do with an admin task. And usually, law firms have systems in place to close or archive files. So that's the whole seller side of the conveyancing. Any questions?
Not so far. No.
So, your task, as I said, is to again research the law in terms of this process that we've discussed today. The best practices as well, as per the protocol. Any further detail of the protocol that you, we need to be aware of, you need to put that in writing and send that to me. Apart from that, any things, any particular things, in-depth things, you need to write them down and you need to send them to me.
Right.
Yep. Perfect, Erica. Yep. Any questions again, just let me know. And
Mm-hmm.
hope to see you next weekend.
Right. See you next weekend. Bye.
See ya. Bye. Bye.